Good evening and welcome everyone to today's discussion on quoting contempt, the fourth in a series of discussions that seek to understand why impunity reigns in this country. But before we move on to today's discussion, I'd like to take a moment to briefly introduce to you what Reach Lawyer is, who is it that we are, and what it is that we do. Reach Lawyer is a legal training and support initiative for civil rights movements, social activists, and individuals to empower them with the power of legal knowledge. While the core of our activity revolves around our work with the legal fraternity, we also undertake various other activities to further legal awareness, social legal advocacy, and most significantly, to collaborate with various human rights groups and grassroots organizations across the country. You can look us up at www.reachlawyer.org to know more about us. Over the past few weeks, and indeed in the coming weeks and months, we hope to start meaningful conversations on human rights related issues that we feel have suffered some neglect and have been subject to increasingly polarized and excessively parochial debate. We hope to be able to start meaningful conversation on a lot of these issues, especially at a time where there seems to be a concerted effort to do away with all meaningful discussion on human rights related issues. With that, I'd like to begin today's discussion with a short video presentation from the renowned poet and scientist Kohar Azar.
नज़्म का उन्वान है माय लॉर्ड। हाँ, मेरा जुर्म है संगीन, बहुत ही संगीन। हाँ, मेरा जुर्म है संगीन, बहुत ही संगीन। मैंने इस दौरे ज़बाबंदी में लब कुशाई की जो जुर्रत की है, जुर्म है। जुर्म की जो चाहे सज़ा। है संगीन, बहुत ही संगीन। हाँ, मेरा जुर्म है बहुत ही संगीन। मैंने इस दौरे ज़बाबंदी में लब कुशाई की जो जुर्रत की है, जुर्म है। जुर्म की जो चाहे सज़ा दें मुझको। जुर्म है, जुर्म की जो चाहे सज़ा दें मुझको। आप हैं ज़िल्ले इलाही माय लॉर्ड। आपका काम था इंसाफ तो इंसाफ करें। आपका काम था इंसाफ तो इंसाफ करें। आप आज़ाद हैं, इंसाफ को जो चाहे शक्ल दें मंजूर। आप आज़ाद हैं, इंसाफ को जो चाहे शक्ल दें मंजूर। आप आज़ाद हैं, इंसाफ को बदला कर दें। आप आज़ाद हैं, इंसाफ को बदला कर दें। आप आज़ाद हैं, इंसाफ को लब सीने का औजार बना दें माय लॉर्ड। आप इंसाफ के खंजर से हर एक उंगली को काट कर फेंक दें, और काटें तो कुछ ऐसे काटें कोई उंगली किसी हाकिम पे कभी उठ ना सके। कोई उंगली किसी हाकिम पे कभी उठ ना सके। आप आज़ाद हैं, इंसाफ को एक बेत में ढालें जिससे सर उठाए कोई गर। उसको सज़ा दें जैसे कोई स्कूल के बच्चों को सज़ा देता है। कोई स्कूल के बच्चों को सज़ा देता है। हाँ, मेरा जुर्म है संगीन, बहुत ही संगीन। आप जो चाहे सज़ा दें मुझे। आप जो चाहे सज़ा दें मुझको। गर इजाज़त हो तो कुछ और भी मैं अर्ज़ करूं। गर इजाज़त हो तो कुछ और भी मैं अर्ज़ करूं। हमको इतिहास बताता है कि हर दौर ख़िज़ा में यूं ही। हमको इतिहास बताता है कि हर दौर ख़िज़ा में यूं ही फूल खिलते हैं तो खिलते ही चले जाते हैं। फूल खिलते हैं तो खिलते ही चले जाते हैं। एक बादल किसी कोने से उभरता है कहीं और सहरा पे बरस जाता है। एक बादल किसी कोने से उभरता है कहीं और सहरा पे बरस जाता है। नंगे पेड़ों की किसी शाख पे बैठी कोयल गाने लगती है तो गाती ही चली जाती है। गाने लगती है तो गाती ही चली जाती है। यूं ही हर सिमत से आती है सदा। यूं ही हर सिमत से आती है सदा, वादियां गूंजने लगती हैं उसी नगमे से। यूं ही हर सिमत से आती है सदा, वादियां गूंजने लगती हैं उसी नगमे से। और कोई कितना भी चाहे कि उसे कैद करे, और कोई कितना भी चाहे कि उसे कैद करे, नगमा हर कैद से आज़ाद बिखर जाता है। नगमा हर कैद से आज़ाद बिखर जाता है।
Hello, all, and welcome to the part 4 of the talk series Why Impunity Reigns. I am Diksha Garg, and today we will be discussing the notion of quoting contempt. The rendition that we have just heard by Gohar Raza has effectively set down the tone for today's discussion. Before we begin, we must take note of the irony that despite having celebrated our 74th Independence Day quite recently, our laws and conduct still cling on to the ideals established by our colonial experience. One such relic of the past that we still hold quite dear to our hearts is the notion of contempt of court. Contempt of court, or simply contempt, is an offense of being disobedient or disrespectful of the judiciary in a manner that obstructs the path of justice. Or at least that is what it was intended to be. When contempt laws were formulated in an imperial Britain, the idea was to preserve the respect and the integrity of the judiciary from the excesses of the executive power. However, the manifestations of the same in India were quite different. Governed earlier by the pre-independent uh, laws and statutes, later and was later codified by various documents, contempt was also recognized as a restriction to the right to freedom of speech. Freedom of speech, mind you, being the essence of a democratic foundation. The tricky position of the contempt laws poses before us various pertinent questions. Firstly, what is the relevance and extent of application of contempt as an offense in a democratic society comprising of citizens with rights and duties? Secondly, and quite in line with the recent happenings, especially in reference with the recent case of Prashant Bhushan, how have contempt laws really helped in furthering the course of justice? Or have the contempt laws been used as a tool to stifle the idea of free speech? Lastly, and most importantly, we must question, do citizens of an independent nation not have a right to hold accountable the institution which derives power from the public? Do we as a people not have a right to criticize and to question? If so, how far can we actually take this right before breaching the dangerous domains of contempt, of sedition, etc.? To answer these questions and more, we have with us today Advocate B.T. Venkatesh, who is the founder of Reach Lawyer and the former prosecutor at the High Court of Karnataka. Joining him is Professor Arvind Narayan, a man who barely requires any introduction. Professor Narayan is the founder of the Alternative Law Forum, an advocate of human rights, author, researcher, academician, and a professor at the Institute of Public Policy at the National Law University, Bangalore. Before I hand over the floor to Mr. B.T. Venkatesh to commence this highly anticipated discussion, I would like to reiterate the words of Lord Atkin, which I believe set the tone of this discussion quite nicely. Justice is not a cloistered virtue. She must be allowed to suffer the scrutiny of respectful, although outspoken comments of ordinary men. With this, I request Mr. B.T. Venkatesh to take over.
Very good evening. Welcome to Reach Law Friday talk show. And today we have a very, very, very important subject, courting contempt. Yes, in fact, last few days, this is the subject which is being discussed by many across the country. The media is abuzz with the subject, will Prashant be sentenced? Will Prashant go to jail? What would happen? What Prashant said, was it a crime? So Mr. Prashant Bhushan, a senior advocate of the Supreme Court, a person who is known for his years of work for the causes in this country. And today he stands convicted for contempt of court on the allegation that he had made 2 tweets, and these 2 tweets are unbecoming of the person. And these 2 tweets have scandalized the institution of the Supreme Court. And I think that's something which has been the bone of contention, subject that's being discussed. And he has been already found guilty of the offense. His only situation now is that he is going to be sentenced. What is the quantum of the sentence that's going to be done was the subject that was discussed yesterday in the Supreme Court. Albeit, while we are talking in terms of Prashant Bhushan's case, is it Prashant Bhushan? In fact, since yesterday morning, we have been discussing on the subject and people are saying it is not the question of Prashant Bhushan, it's the question of freedom of speech. Don't I have a right, could say the Supreme Court? Don't I have a right to say that the Supreme Court has committed an error in a judgment? Don't I have a right to see that if the judges make grave errors, statements which are unbecoming of the court, statements that would misogynistic, statements that are against the very foundations of the Constitution of India, don't I have as a right, as a citizen, a right to criticize this institution? This institution, is it not accountable to me? In fact, when Diksha made the presentation, she asked that very, very pertinent question. Is not Supreme Court accountable to all that she does? The statements that they make, how can you do that? In fact, one of the students who is working with us made a statement. If the judges make serious statements which are scandalizing the court, what exactly is the construct of scandalizing the court? If the judges make statements which are scandalizing the court, misogynistic statements which have no place in the Constitution of India, statements which are against religious overtone, or which do not have a space in the Constitution of India. Is it not scandalizing the court? Are statements that are made in the course of the proceedings in the court snubbing the persons, even talking to the extent of saying that you have no right to make a statement? In that recent case of the public interest litigation before the Supreme Court, where the 2 judges of the Supreme Court made a statement that you read the newspapers and come to PAL to the Supreme Court, when the petition was relating to the migrant labor who are walking to death to their villages because of the most draconian lockdown which was imposed on nearly 150 million migrant labor in this particular country. What was that statement? Was it a responsible statement by a judge of the Supreme Court? What was that statement of the judge who said that you have, if the migrant labor keep walking the distance and they have issues, what can I do about the same? Is it not the responsibility of the Supreme Court to ask the government, ask the institutions, administration to demand that the people are in distress? Is it not the mandate which is emanating from the preamble of this Constitution of our country? I think there's a number of issues which we have to talk in respect of the rights of the people of concern. And that's something which makes it very important that the Floyding series, which we have initiated today, the Floyding series makes that possible, that we are giving that kind of a space and that kind of discussion on the subjects, various subjects, where the rights of the people have been taken away, where the rights of the people have been restricted, where the rights of the people have been suppressed, where the rights of the people have been denied. I think these are the areas which we have been discussing of late. And this particular series is towards that particular aspect. Today, the question is courting contempt. Courting contempt. When I make a statement against the judiciary, I feel that indignant about the same. When I make a statement against the court that the court failed in its responsibility, do you mean to say that I have committed contempt of the court? In fact, I had made in the series itself, we had the cases of Kambalapalli, we have the cases of Jairaj and Benix, we had the case of Chunduru, we had the case of Lakhimpur Bathe, we had the cases of Karamchedu, we had the cases of Khairlanji. Number of these cases where the lists have been done to death, their rights of the humans have been done to death, where in every day we have this 1,789 cases of custodial deaths that have taken place in this country. When these institutions issues come before the court, and these cases, we have seen that people get acquitted despite the fact that the persons have been burnt alive, the persons have been killed brutally, when there are dead bodies around, but still people find there is no justice which is done to these people, and long time which is taken in the travel of these cases. The kind of questions people can ask, people keep asking us, is that, is this judicial system, is this justice system really doing justice? So when I make a question that is this justice system really doing justice, so whether that amounts to contempt, whether that I'm scandalizing the court, whether that statements which is made by the people, which is the opinion of the people, which people feel justified that the systems that they are having for the purpose of delivering justice have not delivered justice. Is it that the people, or the statements made by the people in this country, are scandalizing the court? Where exactly is this kind of construct of contempt of court comes from? I think this is some subject which is to be discussed. In fact, when you look into the case of Prashant Bhushan, we have an accepted procedural essential procedures that need to be followed in respect of any trial of a crime is concerned. Contempt of court is an offense under the Contempt of Courts Act. It's an offense. The moment it's an offense, there is a requirement of certain procedures that need to be followed. It was a case where Prashant Bhushan had very specifically asked that, give me the copy of the complaint. You should know, all of you should know, that the moment there is a complaint against a person and he is brought before the court, that you are supposed to answer this particular charge against you, he must be provided with a copy of the complaint. That's a duty of the court, duty of the institution. There is a specific provision under the law where the copy of the complaint is given, copy of all the allegations, information based on which the proceedings are instituted must be provided to the person of the accused, irrespective of the fact, whatever the heinous nature of the crime that he has been committed. We had given it even in the case of Ajmal Kasab. We had given it in the case of all the terrorists who have been prosecuted in this country. What crime Mr. Prashant Bhushan did, that he was not given a copy of the complaint. And he had to answer the complaint on the basis of the tweet which he had filed, and he had to imagine the kind of allegations which have been made. And there was no specific statement on what basis, on what ground the court felt that it was scandalized by the tweets of Mr. Prashant Bhushan. I think this is something which every person who is accused of an offense is entitled to know about the same. In this particular case, he did not. Albeit, when you look into the situation, Mr. Prashant Bhushan, a senior advocate, presented a detailed statement of objections to it, said that this statement which I have made does not amount to an offense of contempt of court. He had made a very clear statement, there are procedural lapses. He has made a clear statement regarding the way the proceedings need to happen. And none of these questions were answered. In fact, when we look into the judgment passed by the court in the case, in fact, this is the opinion of a great number of lawyers in this particular country who have been discussing on this, that the statement made by Mr. Prashant Bhushan were not answered in this judgment, where he was found guilty of the offense of contempt. And that demonstrates is that the law of contempt is being employed to silence voices. I think this is some aspect which is being discussed by every person. What is this law of contempt? Where this contempt comes from? The construct of contempt, as a lawyer who is a prosecutor, who had officiated as a state public prosecutor, I know that the construct of contempt has two components to it. One is civil contempt and this criminal contempt. I would not get into the polemics and details of the particular law is concerned, but certainly I would like to bring to your knowledge one aspect, that civil contempt is relatable to disobedience of the orders passed by the court. Criminal complaint has series of acts which would amount to an offense as against the institution of the court. What exactly is this offense as against the institution of the court? The offense against the institution of the court is that scandalizing the court is one part of that. In fact, we had this very interesting case which has been quoted by Justice V.R. Krishna Iyer in the course of his judgment, wherein he says that he quotes the case of McLeod versus the 1899 judgment of the Privy Council in the criminal appeal cases, which is very specifically states that in a free nation, there can't be a contempt for scandalizing the court. It's only in colonies of colored people where people need to be made to respect the law and the courts and the institutions. We need to have, there is absolute necessity for having contempt of court. Now, this comes to a basic question. Once we declare ourselves as a republic, once we have become a free nation, once we have freedom of speech and expression guaranteed in Article 19(1)(a), when we have this kind of constitution which gives all, ensures us all the protection under the law, whether that law of contempt takes it away? Is it that this constitution created us as citizens, that we are citizens of this country, but this contempt law treats us like subjects, a subject of a colony? The question here is that contempt is something which the colonial masters used to silence their voices as against the administration. The 1926 enactment. We are strengthening this particular law, wherein that the kind of statements that are made. In fact, when you look into this particular case of contempt, what exactly is the nature of this particular contempt? Where this hails from? What exactly is this that a person can be prosecuted for? Do you mean, in fact, whether one of the statement that was made by a senior journalist yesterday, that he said, if the kind of judgments that have come, scandalizing the whole law, whether that does not amount to scandalizing the court, whether it does not amount to contempt of court, when the judges commit contempt of the court, is it that you just silence it by expunging it from the records? Whether expungement from records takes away the scandalizing of the court? We had instances recently, a misogynistic statement from a judge in High Court of Karnataka. We had recently a statement from a judge of the Meghalaya High Court who said that India should have been a Hindu Rashtra in 1947. We had a judgment when some judge of the Rajasthan High Court said that cow should be made a national animal. Now, when the judges were appointed, whether judges are supported by abided by the Constitution and the words etched in the Constitution, is it not that talking this kind of a language, intemperate language, employing such kind of words which are against the very ethos and principles and construct of the Constitution is concerned, whether that does not amount to scandalizing the institution of the court? I think somewhere these questions are being asked by the people of this particular country. So therefore, our country is asking these questions to this institution. It's not to have to answer these questions to ourselves. It's not that we're answering anybody else. This is a question that we need to answer ourselves. Is it that we have an institution which has to be informed that this is not acceptable? In fact, today, advocates are saying, in fact, all the advocates today, every bar association in India went on strike yesterday, being angry against the way the judgment has been passed as against Mr. Prashant Bhushan. They were angry that expressing one's view has become an offense under the law. I think that's something which is affecting the conscience of the advocates, conscience of the citizen, conscience of every person who feels that he is a free citizen in a free nation. I think somewhere we have all these answers to be given. Somewhere we have to discuss and debate these questions. This will not end, today's discussion will not end a particular subject, because this is a subject which is going on for quite some time and it will go on for some time. This has been put into focus today because of the case of the Prashant Bhushan. I think we should look at this particular law from a perspective that whether free speech is protected, whether this institution, in fact, one of the questions raised by Diksha, a law student, was that whether we, the people, who are the persons who have created this kind of constitution, these institutions are accountable to us, whether these institutions can suffocate the voices when some questions are raised on these institutions. Is it not that the procedural lapses in Prashant Bhushan case is subject to inquiry, public inquiry? Yes, it is subject to public inquiry. Is it not that the proceedings which have taken place earlier in the case of former Chief Justice of India, Ranjan Gogoi, in respect of the sexual harassment cases, in fact, the whole country cried that there was violation of principles of natural justice. There was violation of the procedures How could someone who has been accused of an offense sit on a bench for the same case? How could it happen? I think this is some questions which are being raised. I think these questions are need to be answered. There is a duty for the institution to answer these particular questions. Not answering these particular questions and trying to say that someone who raised the questions as scandalizing the court, I think is something which is a serious lapse. And that's kind of lapse. People are asking questions, journalists are asking questions, advocates are asking questions, lay people are asking questions. Every person who hears this particular case feels that no, it can't be an offense. No, it can't be a kind of judgment which is permissible. This can't be a judgment which can be given sentencing a person for the case. Most of the people have made statements. In fact, it was Attorney General who made a statement in the court yesterday, stating that the 5 judges of the Supreme Court have said that there is corruption in the judiciary. Is not scandalizing the court? Are we going to prosecute those 5 judges, former judges of the Supreme Court, for having made a statement of that nature? I think these are aspects that there need answers from the institutions. These are aspects that people are asking questions. This law of contempt that as we have today, more particularly relating to the scandalizing of the court, I think has no place in a free nation. It does not have a space in free nation. In fact, yesterday when there was a discussion happening, T.M. Krishna, a renowned musician, made a statement. Sedition, defamation, and contempt of court have no place in law books in a free society. They should not be. When we say that we have free speech, these aspects do not find place in law. Someone says that disobedience of the order of the court, do you mean there should be in the law relating to it? It does not mean there should not be a law relating to it. There is a requirement of a law for disobedience of the orders of the court, for sure. But do you have to term it as contempt? You have it as disobedience orders. Disobedience of an order of the court is an offense under the law. But contempt of court is a terminology which is employed a very colonial construct. That kind of construct is something which we need to move away from. We are a different country. We are a developed country. We are 74 years into republic, freedom, and are 70 years into republic, and 70 years of republic. And do we think that we still need to have this kind of laws which are going to suffocate our free speech? In fact, this is a case where number of people have made statements much harsher than what Mr. Prashant Bhushan has said. And his words were guarded words. There was not even a whisper of a statement which was denigrating the institution. So why this becomes an offense? Why all other statements do not become an offense? And these questions, for example, what I'm asking now, the very pertinent questions which I'm asking now, which are based basically on the legal constructs, which we are talking in terms of this amount of contempt. I feel that at this point of time, there is a requirement, a larger debate need to happen regarding this. In fact, this is, V.R. Krishna made a statement that I would like to end my presentation on this. Justice V.R. Krishna made a statement, a very clear statement. The highest is not above the law. The lowest is not beneath the law. A judiciary deviancy commission is a halfway methodology for happy halfway methodology for the purpose of ensuring some degree of sanity. This was a statement made by Justice V.R. Krishna Iyer. I think with that, I would like to make a presentation, come to my end and open this particular discussion with our very, very wonderful guest today, a dear friend and a professor, an academic, a fellow human rights activist who has been in the rights of human rights work for decades now and has put forward amazing body of work. He is an author, he is an editor, he has edited number of books, has penned number of books. He has been contributing, his contribution has been extraordinary in respect of Naz Foundation versus HT Delhi. Then his contribution in Navdej Johar's case, and his contribution more particularly relating to the kind of international principles of additional principles to Yogyakarta principles to the United Nations in his tenure as an officer at Geneva. And the kind of work, body of work which he has done is amazing. And Professor Arvind Narayan is also a person who is committed to causes of the people, a person who teaches in the Institute of Public Policy, National Law School, Bangalore, and is a visiting fellow in a number of institutions and universities, and amazing person who has a wonderful bent of mind regarding research is concerned, and wonderful bent of mind regarding kind of policy issues are concerned. I think today we have him. While we have these questions, I'm more indignant on this particular issue, so and I have so many more questions to ask rather than answers to give. When you look into the kind of things that have taken place and are taking place in this country, I would invite Professor Arvind Narayan to present us what exactly is this. Is there a need? Should we discuss this particularly? Is there a need to rethink the whole construct of contempt of court law? Is there a necessity to rethink the whole construct of this particular law, which is stifling free speech? Is it stifling free speech? Is it not? The process of law is being used in this particular case where a person's free speech has been curtailed merely because there is a provision of law which can be employed to silence the voices of criticism as against the institution which owes its allegiance to or its existence to the Constitution of India. I think I welcome Professor Arvind Narayan to join us, throw light on this particular subject.
Thank you, Venkatesh, and thank you to Reach Lawyer for this very kind invitation and for this really very generous introduction. And thanks to Diksha for really setting the context for our discussion now. And I was thinking, clearly we're all very disturbed by this invocation of the contempt jurisdiction against Prashant Bhushan in this particular case. And I thought we'd try and shed a little bit of light upon this particular case by using three methods. Firstly, looking at what is the role that contempt law plays in a democracy. Secondly, by trying to understand what is the Indian position, what is the case law in India on contempt, and finally applying these two legs to the current case of Prashant Bhushan and seeing how we understand this particular case. If we say thinking of the issue of contempt law within the jurisdiction of a democracy, it makes sense to look at how other democracies have dealt with this provision called contempt. Clearly, Venkatesh has already mentioned that the origin of this law comes from colonial England. That is, we are the happy recipients of this particular law as a gift from the empire. And how has the seat of empire dealt with this particular law? It originates in colonial Britain, but by 1968, the British are very clear that we have to restrict the scope of this law. We don't want to give the judges this kind of power and authority to punish for offenses regarding their own contempt. In 1968, one of the most well-known judges, Lord Denning, says, and this has been quoted in a number of Indian judgments post that, he says, "Let me say at once that we will never use this jurisdiction as a means to uphold our own dignity. This must rest on surer foundations, nor will we use it to suppress those who speak against us. We do not fear criticism, nor do we resent it. But there's something far more important at stake. It is no less than freedom of speech itself." And this thinking in Britain, which evolved in terms of the idea of freedom of speech and expression, was finally culminated in 1931 when the Law Commission came out with a very important recommendation. They made the point that the purpose of the offense is not confined to preventing the public from getting the wrong idea about judges, but that when there are shortcomings, it is equally important to prevent the public from getting the right idea. So in a sense, the Law Commission got it. The saying, you're giving an almost untrammeled power to judges. Sure, they can decide on cases which might be right. They can also decide to utilize this particular power in cases which may be wrong. You're giving power. When there's power in the hands of an individual, it can always go one way or the other way. And they were very conscious of that when the Law Commission came out with this recommendation. And finally, the United Kingdom said that we are abolishing this offense of contempt. So if you go to the United Kingdom today, you can't be tried for contempt because that's not an offense anymore. We go to our other, if we're the world's largest democracy, the world's oldest democracy, the title is held by the United States. We go to the the jurisprudence in the United States as early as the 1930s. There's one case called Bridges versus California, in which the person complained of against uh, against a particular judgment of the court, and the court basically held that there's unfettered discussion of public affairs, and it can only be curtailed in cases of a clear and present danger to the administration of justice. So the test is really this: there must be a clear and present danger. Then we can think of invoking contempt jurisdiction, not just because you feel offended. It's not as subjective as that. There's a stronger test laid down in the United States, and that's early as the 1930s. In Canada, there's a case called R versus Kyoto, where a lawyer criticized a particular decision, calling it a mockery of justice and stating that it stinks to high hell. And the court noted that some criticism may be well-founded, some suggestions for change worth adopting, but the courts are not fragile flowers that will wither in the hot heat of controversy. So, and if you look at the Law Commission of Australia, they look at the logic underlying this entire contempt jurisdiction, and they get into the logic, and this is what they have to say. The logic, of course, is that it impairs the administration of justice. It impairs public confidence in the administration of justice. That's what is asserted. I mean, if you go to a Prashant Bhushan case, the judges asserted ad nauseum. It administers public confidence. It's a scurrilous attack. It scandalizes the court. The assertion becomes the reality, right? There's no further proof of how is the perception of the judiciary affected. How is administration of justice affected? That's really not there. And the Law Commission of Australia tackles that. They say the rationale of the offense, namely the undermining of public confidence in the administration of justice, seems highly speculative. And some might say that it is too vague a principle to justify imposing restrictions upon freedom of speech. So that seems to be the thinking as far as the democracies, the democracies in the world are concerned. And Venkatesh made a very important allusion to a judgment by Krishna which references a 1899 McLeod judgment in the United Kingdom. And the United Kingdom, they make this point. They say that, as Venkatesh rightly said, they said that committals for contempt of court by scandalizing the court itself have become obsolete in this country. But it must be considered that in small colonies consisting principally of colored populations, the enforcement in proper cases of committal of contempt of court for attacks on that court may be absolutely necessary to preserve such a community, the dignity and respect for the court. So broadly put, what is the point? We don't need contempt for our people, but we need contempt for your people. And it's a kind of an insult at its heart to any person who has any sense of nationalism, national dignity at their core. And the person who picked it up again, as Venkatesh rightly said, is Justice Krishna. And I'll read out to you what he said. He said, I will not condemn the Indian people with a contempt manifest in Lord Morris's observation regarding small colonies and colored populations. We are cultured people with traditions and canons and may at least be equated in these matters with Englishmen. That's what Justice Krishna said. But nonetheless, the offense continued in India. And here I think there's one problem we face in this entire contempt jurisdiction, which comes out in the judgment as well, which is, one is it's a law on contempt. Second is we can point out to the fact of the colonial origin, but the fact is today it has a constitutional sanction. Article 129 recognizes the Supreme Court's power of contempt. Contempt is a reasonable restriction under Article 19.2. So we have to find a way of balancing, we have to find a way of understanding contempt in the context of its recognition in the constitutional framework. It's not impossible, but that's a challenge which we have to face, or we have to surmount in terms of how we make an argument against the power of contempt itself. Going down to the Indian case law, there are broadly two strands. One strand which upholds the power of contempt of the courts, and another strand which tries to read down or which tries to mitigate the power of contempt of the courts. In terms of reading down and mitigating, the key person really is Justice Krishna, and is really very, very eloquent and very marvelous judgments on the point. And I'll read it to you the judgments on the other side. The first judgment we have, the first well-known judgment is the 1970s, which is Namboodiripad versus Narayan Nambiar, Justice Hidyatullah judgment. And here again, what is Namboodiripada's offense? He basically states that judges are guided and dominated by class hatred, class interests, and class prejudices. Justice Hidyatullah, who's a learned judge, feels that he has to contest Namboodiripada's understanding of Marxism. He goes into Lenin, he goes into the corpus of Lenin to make the point that Namboodiripad doesn't know Lenin. He understands him completely wrong. It's really what Lenin is talking about is the problem with the class nature of the law. He's not talking about the judiciary anywhere. So that's not. He's misunderstood Lenin thoroughly. But then he goes on to make the very dangerous statement. He says it is clear that it is an attack upon judges, which is calculated to raise in the minds of the people a general dissatisfaction with and distrust of all judicial decisions. It weakens the authority of laws and law courts, and the likely effect of his words must be seen, and they're clearly the effect of lowering the prestige of judges and courts in the eyes of the people. That's Justice Hidyatullah in the 1970s. The other more very recent case of a similar vintage is really the case in 2002, which is the Arundhati Roy case, where again she makes certain comments in the context of the judgment delivered with respect to the raising of the height of the Narmada dam in 2000, and the judges, you can almost make out, are very contemptuous of Arundhati Roy, and you can make this out because the point to be noted is that the council arguing the matter put forward a previous judgment which is actually quite a remarkable judgment. It's a Shiv Shankar judgment. I'll tell you what the Shiv Shankar judgment says and then links up to the Arundhati Roy judgment. Shiv Shankar is in 1988, and Shiv Shankar was at that time the Minister for Law, Justice and Company Affairs under the government. He made his speech before the Bar Council at Hyderabad, where he made what the Supreme Court considered derogatory remarks against the Supreme Court. I'll read out to you give you some flavor of what the remarks were like. The Supreme Court, composed of the element from the elite class, had the unconcealed sympathy for the haves, zamindars, antisocial elements, FERA violators, bright burners, and a whole horde of reactionaries are found a haven in the Supreme Court. So he's quite harshly critical of the Supreme Court. The judges in this case choose to exhibit a certain kind of a broad thinking. They go back to Justice Krishna's judgment and they say that we understand that he's being critical. Perhaps you could use other language, but he's a former law minister. He's making a point which is a legal point. He's making a point, an analytical point. So we really don't consider it contempt. So they give him huge latitude, and the latitude they give him is because he's a former judge and a former law minister, and he knows the law. That's the thinking they go on. And the same argument is made before in Arundhati Roy's case, where the council makes the same argument, saying that you've given this latitude to Shiv Shankar, who's made as harsh, if not harsher critics than my client has made with respect to the Supreme Court. And the judges in this case, they say, the benefit to which Mr. Shiv Shankar, under the circumstances, was held is not available to the respondent in the particular proceedings. Her case is in no way even equal to the case of Namboodiripad. In that case, the contender believed in the philosophy he was propounding. He had made certain observations regarding the working of the court and the prevalent system, which was found to be contemptuous. So I think this is, and they go on to say, the respondent has not claimed to be possessing any special knowledge of the law and the working of the institution of the judiciary. She's only claimed to be a writer of repute. So I think there's a certain gender angle here, which we have to look at a little more closely. Why is Shiv Shankar entitled to relief, and why is Arundhati Roy not entitled to relief? He's an expert. She's not an expert. That seems to be the thinking on which the court goes. These are on one side. On the other side of cases are really again, I was referring to Justice Krishna and his line of thinking. In the 1974 case Badranath, he makes the point that this ancient and inherent power intended to preserve the faith of the public in public justice will not be so used as to provoke public hostility as overtook the Star Chamber, a vague and wandering jurisdiction with uncertain frontiers, a sensitive and suspect power to punish is vested in the prosecutor, a law which makes it a crime to public, regardless of truth and public good. So he's a critic of the sense of a wide range of power which is given to the judiciary. In the next judgment in 1917, S.S. Malgonkar, in concurring judgment, he makes a very similar point. He says, it's a very important point. He says, in contempt jurisdiction, silence is a sign of strength, since our power is wide and we're prosecutor and judge. That's the point which Venkatesh made very eloquently, saying you're prosecutor and you're judge in this case. Surely you have the obligation to follow every small nuance of procedure, not dispense it with it lock, stock, and barrel. And in Prashant Bhushan's case, of course, they didn't, this sense that our power is wide and we're prosecutor and judge didn't seem to animate, didn't seem to motivate the judges. The other very important point they make, Krishna makes, is he says the court is willing to ignore by majestic liberalism trifling and venial offences. The dogs may bark, but the caravan will pass. The court will not be prompted to act as a result of an easy irritability. So these are important points because you think, I mean, when we get to the judgment, you'll see that is the judgment really motivated by an easy irritability? What is the nature of the offense which the judges are so offended by? And we'll look at that a little more closely once we get to the judgment. But the broad point I want to make by looking at this range of case law is that it is inconclusive. One has to say, that reading the case law is very difficult to make the point that Supreme Court should decide this way or that way based on precedent. So the Supreme Court could have gone either ways based on these line of cases. They could have gone either down the Krishna route and said that our shoulders are broad enough that we will shrug off any criticism. They would have gone and made the point that justice is not a cloistered virtue. It comes with the territory. We will get criticism. We will take it. Or they could have gone down the route of being easily irritable. And I think as we all see that they went down the route of being more, as we would say, easily irritable. Let's look a little closely at the Prashant Bhushan case and look at the two tweets. And I think the way to describe this case is really this. It's a two tweets case. Two tweets on which the Supreme Court convicts Prashant Bhushan of convict. So what are these two damaging tweets which really, in a sense, shake public confidence in the administration of justice? That's what we have to look at. And the first tweet, CJI rides a 50 lakh motorcycle belonging to BJP leader Raj Bhavan without a mask or helmet at a time when he keeps the Supreme Court in lockdown mode, denying citizens the fundamental right to access justice. Again, the reference to range of case law, the courts are very clear that if a Chief Justice is upset because of personal comment upon him, the Chief Justice has a right to appeal to take recourse to defamation law. It's not contempt. It has to be a matter which is a public matter. It has to be a matter which affects the public administration of justice. It has to be a matter which affects the confidence of the public. So they have to make that argument and make that case. And they can't make that case on the first part of the tweet. This is the tragedy we have reached into. We have to analyze a small little tweet in terms of its various first part and the second part, but that's the route that the Supreme Court has pushed us now. So the first part is within the terms of contempt law, doesn't come within the nature of contempt. Second part is where they find the problem. He keeps the Supreme Court in lockdown mode, denying citizens the fundamental right to access to justice. Their point is this is simply not true because the Supreme Court is still hearing matters, that the urgent matters are being heard, the institution of justice is still operating, and even Prashant Bhushan had utilized this facility because he appeared before the court himself. And I think one point on the face of it, of course, Prashant Bhushan, no point. He's saying the courts are shut. He's saying it's a lockdown mode. Lockdown mode means reduced functioning. Reduced functioning means there are certain problems with the reduced functioning. And the problems with the reduced functioning, what are the problems with reduced functioning which Prashant Bhushan could be alluding to? Any of us who've seen the way the court function in lockdown mode knows what those problems are. Venkatesh alluded to it. We're talking about the migrant worker issue. We're talking about the unplanned lockdown issue. We're talking about how has the court responded to the misery or the suffering of millions of people in this country? That's the question we're really asking. That's the question Prashant Bhushan is asking. That's the question you read the tweet. That's the sense you get. And again, why did they take this? Why did they decide that this shakes the public confidence and scandalizes the court in that sense? Is he the only person to have made this particular point? And here, Venkatesh made the point again already, but I refer to it again that please read Prashant Bhushan's reply affidavit in terms of how he substantiates each of these two tweets. And that is a powerful documentation of everything that has gone wrong with the Indian judiciary. It's documented word for word, tweet for tweet, point by point. Each point is documented in grave detail, and it's best. And I would imagine that if you're not in an online world, we'll publish that and circulate it so everybody reads it. As of now, I think mainly lawyers have read it, but I think the potential is or something which can be a education in the way the judiciary is operated in recent times. The first tweet, for example, this is all there in the affidavit. So I've done this amount of research, but not research beyond that. Prashant Bhushan has done all the research, and the point he's making is, okay, fine, you're making this case that I'm criticizing the performance of Supreme Court under lockdown. He says that it's not just me who's made this case; it's other judges who made the same case. He refers to a piece by Justice Gopal Gowda titled "The Supreme Failure." What is Justice Gopal Gowda's point? EDM Jabalpur may stand overruled on paper, but in practice, it still appears to be the guiding light for the Supreme Court. Nothing else explains the bizarre orders and observations currently being reported from the Supreme Court. EDM Jabalpur will no longer be remembered as the darkest moment of the Supreme Court. That infamy now belongs to the court's response to the preventable migrant crisis during the COVID-19 pandemic. Read the language. He's referring to the Supreme Court's orders, bizarre orders and observations currently being reported from the Supreme Court. He's referring to it as the darkest moment of the Supreme Court. He's saying that the infamy of the court's response, right? And if this is not strong language, which matches Prashant Bhushan tweet for tweet, I don't know what can be stronger language. And then we come to Justice Madan Lokur. Finally, the Supreme Court hears the migrant issue, and this is what Justice Lokur says. He questions whether this was face-saving attempt to atone for past follies. And then he goes on to say, sorry, he's saying if the court had been given a grade, okay, fine, we give a court a grade for your functioning in terms of the migrant worker issue, what is the grade we'll give you? He says, sorry, the court completely failed in this. Forget what public litigation is all about. If a grade is to be given, it deserves an F. These are two judges of the Supreme Court, their own brethren, who said things which put what Prashant said in a completely as merely Prashant seems to be merely a footnote to the kind of strong observations made by the very brethren of the Supreme Court. Of course, the question of the lockdown mode is something which affects all lawyers in this country as well. And we've seen resolutions around the country where we know that lawyers around the country under lockdown are not able to earn their bread and butter. They're on the verge of destitution, they're on the verge of starvation. Very difficult circumstances are faced by lawyers around the country. And Prashant Bhushan is articulating the grievances of the entire lawyering community when he talks about what the Chief Justice has done under lockdown mode. And this is the officers of the court, be it lawyers, be it former Supreme Court judges, they're all on the same page as Prashant Bhushan with respect to the first tweet. The second tweet is Prashant Bhushan doing what we broadly call crystal ball gazing. And bear me out when you read the tweet. When historians in future look back at the last 6 years to see how democracy has been destroyed in India, even without a formal emergency, they will particularly mark the role of the Supreme Court in this destruction, and more particularly the role of the last 4 CJIs. Again, if you want a devastating and indictment of what the role of the last 4 CJIs is, look to the reply affidavit. And Venkatesh rightly pointed out to the fact that the judgment makes no reference to anything which the reply affidavit has put out. And you can take your own guess as to why the judgment makes no reference. Because you're giving Prashant Bhushan a public podium to basically substantiate every single criticism he's made. And that's a criticism that the judiciary was not able to take. So they said, no, we're not going to deal with this. We're not going to deal with uh, the reply affidavit in at all. Again, when we refer to the criticism of the last four CGIs, perhaps, I mean, not the last four CGIs, just Deepak Mishra in particular, the strongest criticism this country has ever seen of the role of the judiciary has come from within the judiciary itself. And that, of course, we have to refer to the four judges, the three judges conference, and where the judges, three sitting judges of the Supreme Court said that the situation in the Supreme Court was not in order, and less than desirable things have taken place. And unless this institution is preserved, democracy will not survive in this country. They make a very specific allegation to highlight certain judicial orders passed by this court, which have adversely affected the overall functioning of the justice delivery system and the independence of the High Court, besides impacting the administrative function of the office of the Honorable Chief Justice of India. The letter goes on to say there have been instances where cases having far-reaching consequences for the nation and the institutions have been assigned by the Chief Justices of this court selectively to the benches of their preference without any rational basis for this assignment. This must be guarded against all costs. The only point of reading all of this out to you is to indicate that what Prashant Bhushan said is not out of the ordinary, in the sense that other members of the judicial fraternity, including former Chief Justices and former judges of the Supreme Court, have made the same point. So the troubling, the vexing question, why then did the Supreme Court decide to go after these two particular tweets, when there's a whole ecosystem of comments which mirror and reflect and amplify every single tweet made by Prashant Bhushan? I want to refer to one more judge, Justice Deepak Gupta. When he retired, he made this point in the Supreme Court Bar Association. The right to dissent includes the right to criticize. We all must be open to criticism. The judiciary is not about criticism. If judges of superior courts were to take note of all the contemptuous communications received by them, there'd be no work for them other than the contempt cases. In case we attempt to stifle criticism of the institutions, whether it be the legislature, the executive, the judiciary, other bodies of the state, we shall become a police state instead of a democracy. And this the founding fathers never expected this country to be. And what is our hope now in the light of all of this which has happened? Our hope is that the sentiment articulated by Justice Deepak Gupta becomes something like the dissent by Justice Khanna in the emergency judgment. That is, it becomes an appeal that the Justice Deepak Gupta's statement, a sentiment, becomes an appeal to what Justice Khanna called the brooding spirit of the law and to the intelligence of a future day, and the Supreme Court self-corrects the error into which it has fallen. That's our hope of what happens in terms of putting out the fact that the judiciary has many opinions within it, and the judges in this particular case have taken one particular strand of opinion. We believe that's a wrong strand to have taken. We believe that the judges should have been more fully cognizant of the framework of democracy when they took forward this particular line of thinking or this particular reasoning. I think I'll end with the last point, which is the entire question of the Justice. Prashant Bhushan is convicted for the offense of sedition, and then he makes a statement before the court. Again, that statement, I'm sure everybody has read it, but if everybody's not read it, I think it bears repeated reading because it makes some very, very important points. He says, I find it hard to believe that the court finds my tweet has the effect of destabilizing the very foundation of the important pillar of Indian democracy. I can only reiterate that these two tweets represent a bona fide belief, the expression of which must be permissible in any democracy. So at the end of the day, Prashant Bhushan said, I stand by my tweets. I believe that what I said was bona fide. I believe in the rightness of what I said. And then he does a very important thing. He says, I my tweets were nothing but a small attempt to discharge what I consider to be the highest duty at this juncture in the history of our republic. I did not tweet in a fit of absent-mindedness. It would be insincere and contemptuous on my part to offer an apology for the tweets that expressed what was and continues to be my bona fide belief. Therefore, I can only humbly paraphrase what the father of the nation, Mahatma Gandhi, had said on his trial. I did not ask for mercy. I did not appeal to magnanimity. I am here, therefore, to cheerfully submit to any penalty that can lawfully be inflicted upon me for what the court had determined to be an offense and what appears to me to the highest duty of the citizen. At this point, when he invoked Mahatma Gandhi, I felt it's important to go back to the trial of Mahatma Gandhi and read that particular statement. Again, you look at it, the two parallels. We're talking about sedition, which is really against the state, talking contempt, which is really against the court. Gandhiji is convicted of sedition. Prashant Bhushan, in this case, obviously is convicted of contempt. And if you read this sedition statement, again, it's a sense of Gandhiji making a clear statement that what I am doing is the only right thing that I can do. As he puts it, I mean, this very, very powerful statement. He says, affection cannot be manufactured or regulated by law. If I don't feel an affection towards the government, I must have the freedom to give the fullest expression to my disaffection, subject, of course, to the question of violence. So the idea that you have freedom of speech and expression, the idea that you have right to freedom of speech and expression, integral part of this democracy, is something which Gandhi articulated in the sedition trial. So if we think of Gandhi again, I think it's very important to recover Gandhi again as this prime exemplar of the value of political freedom, prime exemplar of the value of freedom of speech and expression, and the prime exemplar of the idea that the state does not own you. The state, the violence of the state has to be critiqued, the violence of the state has to be questioned, be it the legislature, be it the executive, or be it the judiciary. There's one very important, I want to end with what was the response to Gandhi's really almost a magnificent statement at the sedition trial. This is unheard of, right? I mean, as Venkatesh will agree, that as a lawyer, your idea is to say, not guilty. Your idea is not to go there and say, plead guilty and give me the highest sentence possible, which is what Gandhi says. What is the response of the judge? Again, this is very, very important because the judge realizes he's dealing with someone whose moral stature is something which he cannot even match. He says, Justice Broomfield says, he gives Gandhi the extraordinary courtesy and does a statement saying that in the eyes of millions of his countrymen, he was a great patriot and great leader, and acknowledges that he's a man of high ideals in a noble and saintly life. And finally, he convicts Gandhi for 6 years. But by that time in the courtroom, the moral center had cleaved. The question of who was on trial had changed. Was it anymore Gandhi who was on trial? Was the state which was on trial? Again, reading out your statement at that moment, one of the observers says, for a moment, everyone wondered who was on trial, whether Mahatma Gandhi before a British judge or the British government before God and humanity. And as another observer pointed, the trial of the rebel was turned into something that appeared more like a trial of the state. So the question for us is, are we at a similar moment? Can the trial of the rebel become a trial of the state? Thank you.
Thanks, Arvind. And such a joy listening to you. Such a presentation. In fact, it's much needed one. In fact, more particularly for someone from the fraternity, we feel extremely indignant the way our brother has been treated for his bona fide statement. That our brother, a citizen of this country, a person who has been of a very high standing regarding the conscience is concerned, the respect for the institution is concerned, has been found guilty of contempt. That's what in fact makes us indignant. In fact, whole nation is indignant. In fact, yesterday, as you concluded today, That was this feeling of the large number of people. Was the court on trial, or was Prashant Bhushan was on trial? This was something which was on the minds of everybody else in that particular thing. One aspect I would like to add to this whole construct is that the kind, as a prosecuting lawyer, as a lawyer who's officiated as a prosecutor for the on behalf of the state, I find some serious lapses in this particular construct. In fact, what you have stated on the aspect of the broad shoulders of this particular court, we've been talking in terms of the kind of understanding that the system need to have, and at the same time, where and when they think that it has been, this institution has been denigrated to such degrees. I think when you look into all the statements that has come across in last few decades as against the institution is concerned, the statements made by Prashant Bhushan are bona fide statement of serious concern as against the institution, a serious concern that institution need to be protected from such kind of accusations. This institution need to be protected from such kind of attitudes and behaviors, and this institution need to be strengthened. I think that is the whole purpose behind his statement. His anger is not based on his emotional structure, but because of his concern and commitment for the institution. I think the whole construct was misplaced in the judgment which was passed, and without even reference to this particular judgment, he had made an amazing statement regarding the same. But I would like to say one aspect is that, was it a trial in the first place? For me, it smacks arbitrariness. It smacks unfairness. It smacks unfairness for simple reason that every accused is entitled to a copy of the complaint. Every accused is entitled to be given that amount of space. And every accusation that's made against the accused need to be substantiated. If the court come to the conclusion that he has scandalized the court, that at the first instance in the complaint, the court should take cognizance. The time it takes cognizance, it must demonstrate what made the statement made. The court felt that it was scandalizing the institution, because that's a very specific word under the Act of Contempt of Court that need to be explained. None of it was presented in this particular case. He was not even given a copy of the complaint. The very fact that he was not given a copy of the complaint takes away the whole construct that the accused was informed of the accusation. Without accused being informed of an accusation, if you were to conduct a trial, then it's unfair trial. Not my statement. It's a state judgments, canon of judgments. I don't have to go to those list of judgments, because when I talk in terms of the unfairness regarding trial is concerned, we have hundreds and thousands of judgments of Supreme Court which say that unfair trial. And we have books written. In fact, Senior Counsel Colin Gonzalez has come with a book on rights of the prisoners, one aspect relating to unfair trial itself, one chapter only on unfair trials, and he refers to the judgments of unfair trial. What exactly constitutes an unfair trial? Where information is denied to the accused. What constitutes an unfair trial? When the accused is not given opportunity to address. In fact, here in this particular case, the Attorney General, who was about to make a statement, in fact, as a prosecutor, as an Attorney General, as a duty as an officer of the court, every advocate is an officer of the court. Prashant Bhushan is an officer of the court. Attorney General is an officer of the court. We have an equal duty towards the court is concerned. In fact, when a prosecutor appears in the court, he not only appears for the state, he appears for the victim, he appears for the accused, he appears for everyone. He is the person aiding the court to come to a right conclusion. In fact, yesterday when the statement was made, I wanted to add that particular aspect, that Attorney General made a statement that 5 judges of our Supreme Court have said that there is corruption in judiciary. Was it not an indictment? Was not a statement which made very clear that there have been accusations? Now, the question here is, if you were to constitute statement, the second statement which you referred to in the course of the tweet, two tweet case. It's very, very wonderful apt statement, as this is going to be in history written as a two tweet case. So the two tweet case, the second tweet which you referred to, speaks less than what Attorney General told yesterday, expressed before the Supreme Court. Now, if that's the case, what exactly the options? In fact, is there no way for it? I feel that there are several ways towards this. One, that in any trial, at any moment of time, court comes to the conclusion that an offense is not made out, even after conviction is concerned. This is the apex court. This is a court which has abundant jurisdiction to say that this court has erred, because it's a power of review is available to them. Power of review is not only by application, power of review is also suo motu. When you can take a complaint suo motu, you can also review the orders suo motu. Absolutely no bar on that particular aspect is concerned. The court could happily look into this particular aspect, found that yes, Attorney General has made a statement. And also look into the pattern of judgments. In fact, this was yesterday, what was seen in the court was that the silencing of Attorney General by the Supreme Court was something which was not appropriate. From a lawyer's perspective, from a practitioner's perspective, from a prosecutor's perspective, Supreme Court could not have stopped Attorney General from making statement regarding the facts of concern, because it was necessary. And Attorney General is entitled to be heard under the Act, under the law. Attorney General is entitled to be heard, and he has the primacy regarding being heard. And once he is heard, then the court need to come to the conclusion. The statement Attorney General made virtually clearly demonstrated that the accusations made, the statements made by Prashant Bhushan were not alone. In fact, you have made series of statements. In fact, the supreme failure statement by our own Justice Gopal Gowda clearly demonstrates what exactly the indignation is. So the people are indignant. An expression of indignant citizen cannot be contempt. An expression that the courts have failed cannot be contempt. It cannot be termed as contempt. It's not scandalizing the court. The court failed prima facie to demonstrate what actually scandalized it. What part of the statement of Prashant Bhushan scandalized it. I think that was something which was absent. In fact, when you look into the whole construct of the contempt is concerned, I feel these laws have no place in a democracy. These laws need to go from democracy. In fact, the law of defamation need to go from this is the statute books. The law of sedition need to go from statute books, and law of contempt on scandalizing this particular the court, as has been demonstrated and strengthened over a period of time, need to go. You can't have yardsticks. So in fact, let me conclude on this particular aspect. I think everyone who has today heard what Professor Arvind Narayan has said, he gave the statement of Justice Shiv Shankar. He gave the state judgment of the Arundhati Roy. He gave the judgments. He demonstrated two aspects. Was the court treating the accused even-handed? Is it not the duty of the court to treat persons before it even-handedly? What was that? That merely because Shiv Shankar happens to be a former law minister and of erudite nature, that he makes the statement made by him can be absolved of this particular crime, that he has that the kind of credibility? And what was the statement made by Arundhati Roy? Was in fact, it was absolutely nowhere near the statement of Justice Shiv Shankar. What made? And you look into Prashant Bhushan's statement, it does not come anywhere near that. And one very interesting question that comes into picture is making statements against Chief Justice of India is not contempt. It is, if the statement is offended a person of the Chief Justice, yes, Chief Justice has a recourse to defamation. As there is a law for specifically meant for that, he can prosecute in his individual capacity. In fact, it's a very clear statement by everyone in this particular country that Chief Justice is not Supreme Court. Adjudication of court, the adjudicatory process of the court, the judicial administration of the court need to be questioned. That need to be the situation. That means scandalous statement relatable to that particular aspect is concerned. In the tweets which are there, there's absolutely nothing regarding the same. The aspect which Prashant Bhushan have said have been told by 4 sitting judges of the Supreme Court just 2 years ago. They made the statement loud and clear that this institution is not in right condition, that the democracy is at stake. When such statements are made in public by the court, it demonstrates there are issues in this particular court, that there are issues which concern everyone in this institution about this court. And that is our concern too, that this court need to function more efficiently. This court need to function more even-handedly, which has been one of the challenges which have been said. In fact, when you look into the judgment, it's a statement. Any lay person in this particular country would say that how can that be? You can have 2 different judgments merely because one does not know. Do you mean one who knows the law can get away with, one does not know about the law can get away? One because he's a man and another because who's on a woman. This is a gender aspect which you are referring to. So when you look into all these constructs, there is a need that we need to have a relook at these powers of the Supreme Court relating to contempt is concerned, because one aspect is that our system is not weak enough to be scandalized by a statement of a person. I think if we come to such situation that every statement made against the judiciary, a scandalous statement made against the judiciary, even assuming for a moment a scandalous statement made against the judiciary would get into a very difficult situation, perilous situation, I think that's too far-fetched an argument. I think at this point of time, there is a need that these particular law need to look into again. That's as was referred by you specifically, that the powers of the court, the way they exercise powers of the court, it need to be very judicious in its nature. It can't be employed at drop of a hat. And this was case, in fact, it may sound strange, but this was a case of taking up a case of drop of a hat. So therefore, aptly said by you, 2-tweet case. I think that's something which we should take it forward and tell this. And this is there's a larger debate on the necessity of existence of law of contempt as has been stated. Necessity of existence of law of sedition as has been stated. Necessity of existence of a law of defamation as stated. In fact, I would like to conclude. T.M. Krishna, our musician, yesterday was very clear statement. He said that how can we have these kind of laws in this country when you say that we are a free country? I'm entitled to, because these institutions are also accountable to us. These are our institutions. I want my institution to be strong, good. I want my institution to deliver justice to us. I want our institutions to protect our rights. This is the institution which have created, the founding fathers created the institution with this amount of immense powers, a review of the law of the parliament to that degree which has been given, and such kind of powers which have been vested. Are we using it to tweets? I think it's something which should ponder about. It's not the case of Prashant Bhushan, the question of freedom of expression. It's not the case of Prashant Bhushan, it's a question of fair trial. It's not the question of Prashant Bhushan. It's a question of an institution which is founding the kind of issues which are being, people are asking questions regarding this institution. Was it fair, a trial? Was it fair, a procedure? I think there's a way for it. I think the court should look at this particular way, that this is not something which can be construed, I think the wildest imagination, as something which can be construed as an offense under the law of contempt. And this contempt law, as has been used in this particular case, is liable to be closed. If we have to end this particular law, there is a need for ending this particular law. It has been done away with good number of democratic countries. We are the largest democracy. We have functional democracy. We have been for 70 years as a republic now. There are amazing changes. In fact, when I look at the history of my judiciary, I brim with happiness today that the volume of work that it has done, it has set into motion new devices, new aspects, new tools, which are used across the globe. In fact, the construct of the public interest litigation, which we have developed in this country, the jurisprudence relating to class action, which we have developed in this country, goes far beyond the international standards are concerned. It's an amazing concept that we have done. But how come that we are going to have these kind of situations also is question that needs to be pondered and that need to be discussed. I think at this, I would like to close this discussion, but actually this is going to be opening a new discussion on the subject. I feel that there is a necessity for the audience who are there today, need to put your note on this particular subject. Ask questions. In fact, we wanted to have much more discussion on this aspect with Professor Arvind Narayan with us, but given of the paucity of time, we're winding this particular program. I want you to ask your questions, mail your questions to the Facebook page or the through Twitter or to YouTube. You can put all these questions. I think we'll try to answer those questions one part. We also would like to take this discussion forward. We'll have a set of series of discussions of this subject at Reach Law. Reach Law is a place we are trying to create a saner space for a healthier debate, a healthier discussion, so that these discussions really get us more informed. In fact, we could not have this kind of experience, the kind of a scholarship which we have Professor Arvind Narayan with us, explain the whole concepts in a very, very clear, lucid way. I'm very immensely thankful to him today for having joined us and explained the entire subject. In fact, it is a huge subject and he could make it in such a small capsule of a time. I think this is, I would look at it as something opening up the discussion, opening it for this debate for people. I think these are subjects that need to be debated and debated at a level which is different, not the way of noisy interlocution, but from a level where people can ask valid questions, try to explore the same, try to decipher what exactly we mean by contempt, decipher what exactly we mean by the fairness, decipher what exactly we mean by proper judicial process is concerned. I think these are the areas that this discussion debate would open up. I think I'm immensely thankful to Professor Arvind Narayan for having joined us today and made the day so beautiful. Thank you, sir. Such a joy.
Thank you. Thank you.
On behalf of the Reach Lawyer team, I would like to extend my gratitude towards Mr. B.T. Venkatesh as well as Professor Narayan for taking out time from their busy schedule and trying to enlighten us regarding the contempt laws. On the basis of the discussion, there is a clear need to unravel the contempt laws as well as thoroughly re-examine them. In a line to conclude, I would like to quote Lord Justice Bowen, who said that the point or the necessity of the contempt law is not really to vindicate the judiciary, but really to only prevent the undue obstacles in the path of justice. So, keeping that in mind, I think the Indian judiciary really needs to re-examine its stance on contempt laws, especially in the light of recent happenings. Thank you.